Good afternoon, everybody. Welcome back to another Q&A session. My name is Chris Justice, and as you see down below, I'm an employment lawyer with Samfiru, Tumarkin. I work out of our firm's Toronto offices, and as I say, as always, I show up here today to do a bit of Q&A. So if anyone's watching, you've got questions relating to the workplace, maybe you've got a question with respect to a contract that you want reviewed, or you've got a question regarding something that's been going on in your workplace, or maybe you have a question about something that's happened after your time has come to an end at a particular workplace, just get your questions in here today. And as I say, I'll do my best to answer as many as possible. Before we get into questions, as I normally do, I like to talk about at least one or two topics off the top. Might be a news story, might be a recent case of mine, just looking to pass along some information. So today, what I thought I'd start off by talking about is a recent piece of legislation that has come into effect. It's called Bill 88, and it deals with employee tracking from an electronic basis. So as we all know, a lot of us have been working from home since the onset of the pandemic. And in part, this new piece of legislation is looking to address situations where employers may want to track what their employees are doing. So I wanted to just touch on this bill and sort of what its general impact is in the workplace. So a lot of people may not know, but if you are using company property like a laptop or a cell phone, companies are generally going to have the ability to monitor the use of those items if you're in fact using them during business hours. Whether or not there may be a policy in place is another thing, but people need to realize that if you are using a computer, laptop, or phone that's been provided to you by the company, that there's a good chance they either can or have been tracking your sort of actions on that device in some way or another. And what this new legislation does is to hopefully bring some clarity, some transparency to all of this, so that employees are aware of, to what extent things are being tracked. So in that sense, it's a good thing. As I said, the legislation has come into effect recently. So any company that's got more than 25 employees has to now have a policy in place, something in writing that addresses what tracking goes on and what reasons the tracking's done for to begin with. A lot of people may be wondering about potential privacy issues when it comes to employers tracking various devices that they may have. And no doubt there are definitely concerns, because I'm sure a lot of employers have or maybe will go a bit too far in their efforts to track certain devices, and that will naturally bring into the conversation issues of privacy. But employers still can have these tracking policies put in place, so long as they're connected to a legitimate business reason, as well as being as minimally intrusive as possible. And if the company can show that there's a legitimate business reason and show that they're, sort of tracking someone in the least intrusive way possible, then there's going to be much more of a likely chance that that employer is going to be fine with that particular policy. If it goes a bit further and there doesn't seem to be a rationale or a reason connected to why they're tracking you, or maybe there does, but they're just going way too far about going in terms of going about doing it, then that's when you get into the territory of privacy issues. That's when there might be a bigger issue at play. So if you're an employee and you've now been told, or you're aware of there being a tracking policy of some sort in place, and you feel as though it goes too far, what I would suggest is, before maybe broaching that subject with your employer, give us a call. You need to speak with a lawyer. Because you need to understand maybe the best way to communicate your concerns. You don't want to be too aggressive and maybe possibly quit or tell your employer that you're going to leave them if they insist on the tracking to happen. Again, these are discussions that you need to have with a lawyer first before you go in and sort of either negotiate or just communicate with your employer. There may be circumstances where somebody breaches a tracking policy and they get let go. If you've at all been let go as a result of there being an allegation that you breached a monitoring policy or an electronic tracking policy of some sort, again, another reason you're going to want to call us, because there's definitely a very good chance that you're going to be owed severance. So don't think that employers can necessarily let you go because you don't want to agree to a tracking policy of some sort and then not pay you any severance on the way out. That's going to be highly unlikely, and you're still going to be likely entitled to your full severance entitlements. So I wanted to just, as I mentioned, sort of talk about that off the top today. I think we'll probably be hearing more about employee tracking further on down the road. Given that this legislation has just come into effect, I imagine there's going to be cases, as I say, in the future that might deal with real privacy concerns. Like, for example, if your employer is asking you to be on camera and recording you from a remote sort of location through your camera on your laptop or your computer, that's going to be a much bigger privacy concern. If an employer is asking to record your telephone calls or track your calls from your cell phone, maybe even your personal cell phone, that's going to likely attract more privacy issues. So it's still an evolving area of law, but I just thought, as I say, it would be important to kind of just touch on this new piece of legislation and what it might mean in terms of the workplace. Having said that, I'll get back into the other topic that I was going to talk about at the top of this session, but I do see some questions in here. So I'm going to try to answer as many as I can. Just keep getting your questions in if you've got any. But I'm going to start with JBK on YouTube. JBK is saying that they were denied EI benefits because they're not vaccinated, and this is going back to November of 2021. But since November of last year, things are being lifted. And so JBK is wondering if, now that the mandates in various areas have been lifted, is it now possible to get back pay for being placed on a suspension or a leave of absence or not? And is it also possible, JBK is asking, if they can get called back to work? So first of all, JBK, I would say that, when it comes to individuals who were denied EI benefits for not complying with a vaccine policy, the most important time period is going to be at the time the vaccine policy was not complied with. So if you have, let's say, breached a vaccine policy in November of 21, the people at EI and the courts in this province are likely going to look at what the state of things were back in November of 2021 and pay less attention to things that have happened in the future. That said, is there a chance that someone can get their EI benefits or some severance based on mandates being lifted? I think it can play a role. I think it's going to be hard to ignore the fact that there have been a number of mandates that are lifted. But I think, again, the key thing will be how was the world like essentially in November of 2021? So JBK, I wouldn't say that you should not keep trying to get those EI benefits. I think it's good for people, if they're denied EI benefits, to appeal that decision. For the reasons that I'm sure are going to be the same as why you applied for EI benefits to begin with. But yeah, in terms of using the future events that have happened to help support your argument, it's just going to be a little bit tricky for the reason that I mentioned. Having said that, though, JBK, and this applies to anyone, if you're somebody who has lost their job or has been placed on an unpaid leave of absence because you have not complied with your company's vaccine policy and you've been going without income all this time, definitely give us a call. Regardless of whether or not you're entitled to EI or whether you will receive EI, you may have a claim for severance against your former employer. And so if you're someone who has been, maybe in JBK's scenario, placed on an unpaid leave of absence or let go back in November, and you're looking for back pay going back that far, the best chance that you would have in getting that would likely be to pursue those amounts, pursue that back pay from your former employer. And that's something that our firm can definitely help you out with. we can definitely get everything sorted so that you can have as best of a case possible for severance from your former employer. So JBK, I would say if that's at all appealing to you, you want to give us a call so we can look into that for you and not only potentially get your back pay, but also potential future payments beyond April. Although I just noticed, JBK, that you were called back to work in April. So in order typically to get severance, it's going to be harder for you to get severance if you return to work. If you're somebody who maybe, unlike JBK, is still off work, then what I said is definitely applicable. You can go after the company for severance. If you go back to the company after you're placed on a leave, then it's going to be more difficult to get the back pay because in a way you have shown that you were maybe accepting of the layoff or of the suspension from November until April. I'm not going to say that you're 100% unable to get the money, JBK, but as I say, going back to work can sort of lead to the implication being that you were okay with staying off. So it might be actually more difficult, but I would still suggest you give us a call and we can at the very least look into it and try to see if you can get you something for all that time that you had taken off or that you were at least placed on that leave for. But thanks for your question, JBK. I think it's important to sort of touch on things that I know a lot of people are going through right now. And one of the biggest issues right now that I'm facing in my practice is having to talk to people who have been cut off benefits or been terminated or placed on a suspension for their failure to comply with the company's vaccine policy. And a lot of people I talk to think that they don't necessarily have any rights beyond that point, which is not true. They absolutely do, and they can potentially get their full severance. So whether it's you, JBK, or anyone else, if you're in that kind of a situation, you want to give us a call. I've got another question in from Kara on Facebook, who is asking, if you're dealing with ongoing bullying at work, can you record a conversation as proof? And so a lot of people seem to think that recording somebody without their consent means that they're not able to use that recording for future reference, which is not true. There are absolutely circumstances where the person you're recording may not know they're being recorded, but where you can still use that as a record for later on as proof of, whether it's bullying or harassment. That's one thing. Obviously, if the individual is aware of the recording happening and consents to the recording happening, then there's no issue there at all whatsoever. And it is always good to have a record in general when it comes to issues of bullying at work. If you're somebody who is just going through bullying, harassment, some form of a toxic workplace, and you're thinking, you may not be able to last there much longer. First of all, before you quit or resign or anything like that, you want to give us a call. But secondly, as I mentioned, in general, it's just always good to have a record. So whether it's something that you put in writing to sort of document maybe a discussion that was had, or you actually make a recording of it on, say, a phone or an audio recorder of some sort, you're going to want to do that at the very least, because even if you may not get all of it in as evidence, it's good to at least have that record, knowing that there might be a dispute about that later on down the road. So yes, in general, Kara, the answer is yes to recording conversation as proof. But thank you for the question. I think it's, again, another important one, because I know a lot of people are going through issues in the workplace, but also after I get done talking with them, the evidence aspect can be problematic or become an issue. But thanks again for your question. I've got another one in from Pete Chan on YouTube, who's asking or saying that they became mentally ill at work. They spoke up and they had to eventually go on short-term disability. HR, Human Resources, investigated the complaint, and I guess there was a complaint of retaliation, and HR's response was that it's not retaliation, and that there's, I guess, a lot of evidence in terms of, it's not quite clear, but maybe evidence in terms of the company's response to the complaint. And P. Chan is just adding on that they were given a warning letter saying they were rude when interacting with employees, and they're asking for evidence of how and when they were rude. So P-Chan in general, and this applies to everyone who might be in a similar situation, if you are being faced with criticism from your employer, like in P-Chan's case, maybe you're given a warning letter that says you are not performing your job well, or says that you're being rude, or says that you're breaching some policy of the company. Anytime something like that is sort of launched against you, and you disagree with what the company's saying, you're going to want to put in writing your disagreement. You're going to want to say, in P-Chan's case, maybe you're going to want to respond to the warning letter, and specifically say why you disagree with the allegation, and also, as you mentioned, P-Chan, ask for the evidence as to how and why you were rude. If a company is going to make certain allegations against you, then of course it has to be prepared to back up what it's claiming. So I think you're entirely within your rights, not only to object to the criticism or the warning letter if it's not true, but also ask the company as far as where they're getting their evidence from to support that claim. Now, P-Chan's also saying that HR investigated a complaint that was made, but responded to say there's no retaliation. So it seems like in P-Chan's case, the employer is not saying that anything necessarily was done wrongfully against P-Chan, but that brings up another issue. When human resources investigates a complaint, maybe you as an employee, you launch a formal complaint against somebody in the workplace. Maybe someone's harassing you, bullying you, subjecting you to some form of problematic action, and you submit a formal complaint. HR is generally, or the company are generally required to then conduct some form of an investigation. And it seems like something like that was done. But it seems in P-Chan's case, the investigation results came back and they did not validate or justify P-Chan's position. So maybe the company took a different outcome or conclusion with respect to the complaint itself. And just like when a company gives you a warning letter, if somebody performs an investigation and you feel as though the investigation is faulty or insufficient in some way, you're going to want to make a record of that and state that for the record so that it's clear that you're taking issue with the investigation. Again, hopefully the company will be able to respond to tell you what steps were taken during the investigation, give you a sense of how they exactly arrived at that conclusion. If you yourself are the one that submitted the formal complaint, then you're going to be generally entitled to knowing about how the investigation is going, and certainly about the outcome. And depending on what the outcome of the investigation is, depending on what evidence the company has, which again, if you're not clear on that, you should ask them, they're going to release a decision of some sort. If it's still unsatisfactory or an issue from your perspective, then there may be an issue of still the investigation being faulty or biased or again, problematic in some respect. And so P-Chan, if you're in this situation, and you're still unsatisfied with the outcome, I think you should give us a call. It seems like in general, there's a lot of issues going on with respect to your specific situation. Things like, you being given a warning letter, your complaint being investigated, but being essentially denied. You mentioned there's some mental illness at work, so there could potentially be human rights concerns there. Depending on what your company is saying and how much pushback you're facing from them. So it seems like there's a lot going on. And again, it'd probably be better to schedule a more fulsome consultation where we can kind of go through everything and at least make sure that you're communicating the right things that you need to your employer, so that later on, you're not having, said something that might come back to bite you in the butt later on. But thanks for your question in any case. I've got a follow-up comment from JBK, who was earlier saying they were denied EI benefits for not complying with the company's vaccine policy. They believe they feel like they're discriminated against for not being vaccinated. And so a lot of people I've spoken to, those who are not vaccinated or not willing to get vaccinated, they share the same thought as you, JBK, that there is some form of discrimination in terms of how those who are unvaccinated are treated with those who are vaccinated. And, in general, JBK definitely is a difference in terms of how those two groups of people are treated. However, it may not necessarily, at least in this province of Ontario, mean that there's discrimination. And I say that because the Ontario Human Rights Commission themselves had earlier released a statement saying that if you are someone who is personally of the belief that they do not want to get vaccinated, that is not, I guess for lack of a better phrase, good enough of a reason for you to be given protection under human rights legislation. On the other hand, JBK, if you are somebody who cannot get vaccinated for medical reasons, and you've got the support from your doctor, or you are someone who is maybe a devout religious person and you have testimony or statements from your religious leader that speak to your objection to vaccination, then there can be human rights concerns involved. And you can, I think, have a better leg to stand on in terms of whether there's been discrimination or not. At least you'll have a stronger case. So depending on what your situation is, JBK, or anyone's for that matter, if you are without a job or you're stopped getting paid because you're not complying with a vaccine policy and there's a legitimate human rights reason behind it, then 100% there's definitely the possibility of discrimination, which would involve you then not only getting possibly severance, but also damages for human rights concerns. So that may be a situation or a question you want to dive a bit deeper in with us in a full consultation. So give us a call, and I think we should be able to help either way. But I do appreciate the follow-up on that, JBK. I've got another question in from Lawrence on Facebook, who's saying that they've been sent an offer for a new job. They already have a current job of 6 years, but the new job has better pay and benefits. However, Lawrence is worried about new employment because we're heading into a recession, and Lawrence is asking what he should do. So, yeah, definitely if you are at a job right now and you've been working for several years and you're worried about losing your job just in general, if you lose your job after 6 years at the current job, you're likely going to get much more severance. If you leave your current job and join the new job, and then you're let go very early on into that new job, then you're at risk of essentially foregoing those 6 years that you had with the previous company, and only being seen as an employee with maybe a year or less. And then if that happens and you're let go, then you're potentially only going to get a half or less than half of the severance that you would have got had you been viewed as a 6-year employee. Now, on the other hand, Lawrence, if you are essentially incentivized or induced to leave your job that you maybe don't want to leave, but you're induced or incentivized to leave by the new employer, and then you're let go, if inducement is there, and that's a key part, if you were actually induced to leave and it's almost as though the employer, the new one anyways, is just, insisting you come over with them, and then you lose your job, you might be able to take into account the previous 6 years. But Lawrence, I think in general, you're going to want to talk to a lawyer as well, just in terms of getting a better idea as far as what you might be owed at your current job if you're let go after 6 years, and what you might be owed at the new job if you end up signing a new contract. Because that's the other thing too, is that this new job, unlike your old one, will ask you to sign a contract. And that contract may be a lot different than any previous contract you signed, which then could have a knock-on effect and result in potential rights being lost later on with the new job if you lose your job. So, whether it's going over the contract, going over the situation with the current job and the new job, I think there's a lot to discuss there. And you just want to be careful what you do before you accept a new job, and certainly before you sign a contract. Especially if you have concerns about heading into a recession and potentially losing your job, you're going to want to call a lawyer and get some advice. P-Chan as a follow-up question, P-Chan being the individual who filed a formal complaint against his employer. and he was asking, or they were asking, for a third-party investigation after HR said that there was no finding of any bad doing on the company. P-Chan saying that they asked for a third party to investigate, but was denied the opportunity. So that may or may not point to bad faith, P-Chan. Not to say that someone is necessarily entitled to a third party investigation, although usually when there's a third party involved and it's not the company doing its own investigation, there's going to be less of an appearance of there being bias. So your request might very well have been valid, but again, that would be something we would have to assess further in a consultation to get some more details. But thank you for your follow-up comment. I've got a comment in from Maribeth on YouTube who's asking for help to get severance pay because they're saying their union seems unable to help them. So this is just a general comment for those who work within a union. Our firm does not specialize or do union work in general. So ordinarily, we're not able to help you in those circumstances. I would say that if your union is not able to help you, it's going to depend on why your union is not able to get you severance. If you feel like your union is not representing your interests in the way that it should be or could be, then as far as I understand, those who are unionized have the ability to file a duty of fair representation claim against their union, which is basically an argument to say that the union is not doing its job. They're not providing fair representation. So that would be one possible option. Maribeth, I would also refer you to the collective bargaining agreement, which may set out some additional procedures when it comes to unions not supporting you and what process to follow or what steps to take. But as far as we're concerned, it's going to be very difficult for us to help you until you go, at the very least, through those steps first. I've got another question in from JX2 on YouTube. JX is stating that they were given some, it's not quite clear, but they were given some something regarding COVID vaccines, but requiring other vaccinations. Is that a form of discrimination? JX, yeah, you'll just have to be a bit more clear with your statement. I see your other comment saying they can write into a contract that if they take a new job, that new employer agrees to carry over entitlements, can't they? Okay, so let's address that first. So if you're leaving an old company and joining a new company, absolutely the new company can put in the contract recognition of your past service. This is particularly relevant when there's a sale of a business. So let's say you work for one company and they get bought out by another. You definitely want to make sure that if you're going to join with the other company, the buyer, that there's something in the contract that recognizes all the previous service with the company that sold the business. So that more so pertains to, as I say, when there's a purchase and sale, you want to make sure that recognition is given. As it pertains to completely different companies, that's not at all like that situation, then it's going to be not necessarily the case then that there's going to be reference in the contract to the years of service. But it'll just come down to the particular scenario, JX. But yeah, I'm sorry, I can't answer your previous question just because it's not quite clear. But I would say if you have a question, or if anyone has questions about COVID vaccines, whether they're discrimination, whether someone's entitled to severance, absolutely. There's lots of scenarios where someone's let go due to non-compliance with COVID and they are entitled to severance. So in general, if you're in that situation, give us a call and we'll let you know what your full severance entitlement rights can be. Otherwise, as you see down below there, you can join us again live at 4 p.m. With Darren Saul. So that's Tuesday, tomorrow, October 18th. And he would be happy to answer any further questions that you guys might have. But thanks again for tuning in today. And I will be back, as always, later on, back to answer as many questions as possible. But until then, do take care and enjoy the rest of your day. All the best. Bye for now.